This is Peter Laughlin. Welcome to today's presentation. I am very happy to report that the widow penalty has finally been eliminated. Congress recently enacted new relief for surviving spouses of U.S. citizens and for their eligible family members, and President Obama signed this into law on October 28, 2009. Today's presentation is brought to you by Goldman & Laughlin, the immigration-only law firm. Please visit our website at usimmigrationteam.com. Before proceeding, I would like to go through a brief disclaimer. The information provided today is for general education purposes only. You know that each case and its circumstances are unique and is therefore not possible to give specific advice or give legal advice in a presentation such as this one. If you do require legal advice, please feel free to make an appointment or to contact an attorney of your choice. What is this new legislation all about? All widows and widowers of U.S. citizens and their children may now self-petition to obtain lawful permanent residence, that is, ultimately to obtain a green card. In addition, self-petitioners may even be eligible where the widow or widower resided abroad at the time of his or her U.S. citizen spouse's death. That being said, you need to be aware that the surviving spouse must not have remarried. Now, this is strictly, mind you, in self-petition situations. I have an asterisk here because there may be situations in which the U.S. citizen spouse filed an I-130 petition prior to their death, in which case the surviving spouse's remarrying would not necessarily render them ineligible. We're going to cover that more in detail, and in fact, I cover this from a couple of different perspectives so that you are fully aware that there may be different strategies to use whether or not you are remarried or whether or not your spouse filed a petition on your behalf prior to his or her death. Now, there already was an existing law since the 1990s, in fact, that protected widows and widowers of U.S. citizens. So how is this new law different? The previous law required that a widow or widower have been married for 2 years in order to be eligible to self-petition for lawful permanent residence. Fortunately, the new law dispenses with this requirement, thus allowing relief where the marriage was for less than 2 years. But retained in the new law is a provision that the widow or widower must provide evidence that the marriage, in fact, was entered into in good faith. In other words, that it was a bona fide and valid marriage. Perhaps the most common question we get about the new law is just how to apply under this new law. Widows and widowers married for less than 2 years at the time of the U.S. citizen spouse's death may self-petition by filing on Form I-360. However, very important here, the I-360 must be filed within 2 years of the passage of this new law. In other words, there is a deadline. As I said in the beginning, President Obama signed this law on October 28, 2009. Therefore, the deadline is October 28, 2011. So if you're going to be filing an I-360, you must do it by this deadline. Very, very important. In addition, self-petitioners may concurrently file to adjust status at the same time that they file their I-360 self-petition. In other words, they can file to adjust status to get a green card at the same time. Another great benefit is that there is no requirement for an affidavit of support to be filed with the adjustment of status, which would typically be the case. Now, as I promised you in the beginning, I'm going to be covering different aspects of whether or not there was a prior petition filed by the U.S. citizen spouse or whether or not the surviving spouse remarried. Let's do that now. What is the effect of a prior petition, that is an I-130 petition filed by the U.S. citizen spouse prior to their death? Widows and widowers who were the beneficiary of an I-130 petition of a U.S. citizen spouse will likely be treated as having the petition being converted to a self-petitioned I-360. I am quick to point out here that I say likely to be treated as having the petition converted to a self-petitioned I-360, and that is because the law is just so new that its exact implementation is not fully known yet. However, based on past practice, it is likely that it should be treated as being converted to a self-petitioned. Similarly, widows and widowers who were denied under the old law will likely be able to reopen their cases. Again, owing to this uncertainty here, and I fully expect over the next several weeks or even months that this will be cleared up. However, if the uncertainty remains for any continued time, I want you to be aware that you must file a self-petition I-360 prior to the deadline of October 28th, 2011 in order to preserve your rights. So if this lingers and it's not cleared up and it approaches the deadline, you'll want to be certain to preserve your rights by filing an I-360 petition prior to that very important deadline. How will remarriage affect eligibility? If a U.S. citizen spouse filed a petition for his or her surviving immediate relative spouse that was approved or even pending at the time of death, the surviving spouse is eligible to adjust status, even though they may have since remarried. That is, so long as the widow or widower resided in the United States at the time of death of the U.S. citizen spouse and that they continue to reside here in the United States. For clarity's sake, let's cover again what occurs where there is no petition filed by the U.S. citizen spouse and the widow or widower after remarries. The law seems clear that surviving spouses who are not the beneficiary of an I-130 petition filed prior to the death of their U.S. citizen spouse are not eligible to self-petition if they are remarried. However, I again want to point out that the law is very new and its exact implementation is not completely known. Therefore, I advise you to monitor things closely to see if allowances will be made for remarried surviving spouses. Are children covered under the new law? I'm happy to report, yes, unmarried children under the age of 21 may be included in the I-360 self-petition. Also, children who are unmarried and under the age of 21 at the time a petition, an I-130 petition, was filed by the U.S. citizen spouse should also remain eligible even if they turn 21 prior to the enactment of this new law. I would also like to stress here that if there are any circumstances in which your children are close to reaching their 21st birthday, please do not delay in self-petitioning with an I-360 if you're eligible. In other words, you want to act not only to preserve your rights under the new law, but to preserve your children's rights as well. Finally, let's go over some of the other benefits of the new law. The new law adds several new sections to the Immigration and Nationality Act, one of which provides for the beneficiary and derivative beneficiary of a petition, notwithstanding the death of the petitioner, where the beneficiary or derivative relative resided in the United States at the time of death and also continues to reside in the United States. Now, such benefit can extend to immediate relatives, family preference relatives, employment-based derivatives, and asylee refugee beneficiaries, among others. This concludes today's presentation. The presentation has been brought to you by Goldman & Laughlin, the immigration-only law firm. Please feel free to visit our website at usimmigrationteam.com for some more useful information. My name is Peter Laughlin, and I would like to personally thank you for visiting today, and I look forward to seeing you on future presentations.